The Supreme Court isn't actually supreme, and both Thomas Jefferson and James Madison insisted that it wasn't. Think about the logic here for a moment. Would the founders really have created a government with limited powers and then given that same government the authority to determine the extent of its own powers? This would have been seen as absurd and dangerous. As Thomas Jefferson put it, the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion, and not the Constitution, the measure of its powers. Madison took a more moderate stance. He conceded that the federal judiciary was the final arbiter in disputes between the branches of the federal government, but he insisted that it could never have the final say when it comes to the extent of federal power in relation to the states and the people. In his famous report of 1800, Madison said because the states are sovereign parties to the Constitution, it follows of necessity that there can be no tribunal above their authority to decide in the last resort if the Constitution is being violated. As a result, he said the states must themselves decide in the last resort such questions as may be of sufficient magnitude to require their interposition. Jefferson took a different position. He said the Supreme Court wasn't even supreme over the other branches of the federal government. In a letter to Spencer Roane, he said this notion of judicial supremacy would make the Constitution a complete suicide pact. He went on to write that as he understood it, each department is truly independent of the others and has an equal right to decide for itself the meaning of the Constitution in the cases submitted to its action, and especially where it is to act ultimately and without appeal. So despite what everybody tells you today, the notion of total, final, absolute supremacy of the Supreme Court is a myth.